So the federal registration process can take a number of different pathways. Typically, you may consider doing a trademark search. The trademark search can be at a number of different levels. One of the best things is to start with Google, but that generally is not always enough. A knockout search can be done, sometimes just with the U.S. Patent and Trademark Office database. An important thing to note is that the trademark examining attorney is not going to be looking generally at common law usages, usages that don't exist in the database of registered trademarks and pending trademark applications. They're limited in scope. So if you want to have a pretty good idea of whether your federal registration is going to go through or not, you really need to focus on the U.S. Patent and Trademark Office database of registered and pending applications, because that's what the examining attorney is going to look at. But is that usually enough? Well, if you're going to invest any kind of significant money into the branding and marketing of that trademark, then you probably also need to look at common law usages. And there's, again, various levels of trademark searching. One of the top levels of searching is called a full clearance search, and that's where you generally have a search provider that returns records from corporations in all 50 states, yellow page ads, internet websites, and they look for any mention of that brand in conjunction with any kind of product or service anywhere near what you intend to offer. So if you're already using a brand and you've been using it for many years, then the trademark search may not have this high priority. In contradistinction, if you have one brand or several candidate brands and you're about to launch an expensive marketing campaign and you haven't offered the product or service yet, then that is probably a prime candidate for doing more aggressive trademark searching, making sure that you have a reasonable belief that that trademark is going to be available for use and registration. But one fundamental thing to always know is that no ethical intellectual property attorney can guarantee that any search is going to completely clear a trademark for use and or registration. You can spend thousands of dollars searching a trademark, and then something can come out of the woodwork and pose a barrier to use and or federal registration. So doing the search may be a good investment. It's an insurance policy, but it will not completely protect anybody from at least some business risk that every company has to incur. The two main paths for doing a federal trademark registration are one called an in-use application, and the other one's called an intent-to-use trademark application. An in-use application is one where, as it sounds, you're already using the mark in commerce, and you have an example of how the mark is used. Now, if you're offering a service where there's no tangible product being sold or transferred across state lines, typically a website is usually a good example of use because it's available throughout the world and it's accessible by other people. And as long as your brand exists on that web page, and also, very important, there has to be some indication of what product or service is being offered with that brand, so specifically a service. If you are dealing in a tangible product, let's say a mouse or or bricks or anything else that can be physically held, then that brand needs to be affixed or associated some way with that tangible product. Now, if you can imprint it directly on the product itself, that's wonderful. Sometimes that's not practical. You may have to do a sticker or a tag, or in the box from which the product is delivered, you can actually put the brand on that box. But it's very, very important for the end consumer, the person that you are targeting, to associate your product with your brand, and that is the core fundamental value of a federal trademark registration and the trademark system as a whole, is to associate your company, that product, and that brand, so that if they like that brand and they want to recommend it or they want to use it again, they identify it by that trademark. Trademarks typically take about 4 to 5 months before they're picked up and examined. So we file them in January. Sometime generally in April or May, you'll get what we call a first office action or response back from the U.S. Patent and Trademark Office. In many cases, they approve it for publication, And at that time, maybe a few months later, they get published for 1 month. And during that 1 month, an entity that feels they would be damaged by registration of that trademark can file an opposition proceeding. An opposition proceeding is handled at the Trademark Trial and Appeal Board. That's where two parties can exchange and present evidence of use, and in many cases that they had been using the trademark earlier than the other entity that applied for it. Trademark Trial and Appeal Board cases, sometimes we call them TTAB or TTAB cases, they are quasi-federal litigation. You can file interrogatories, requests for admissions, in some cases even take depositions. There's no courtroom. It's done by paper. But like any case with discovery and getting attorneys involved, you don't always have the ability to control the costs of the project, much like you would with a federal trademark registration. Why? Because you have another side, you have another opponent, and if they want to engage in greater discovery and file motions, then it requires your side to respond accordingly. So Trademark Trial and Appeal Board cases, they're not that frequent, but when they do happen, it's very important to speak with the attorney and understand what the drawbacks, what are the strengths of your case, and what is an appropriate legal budget to respond effectively. So again, in most cases, you don't have a opposition proceeding, and the trademark is registered thereafter. But the other pathway when we talked about as opposed to a use application is what we call an intent to use application. These are filed very frequently. They are filed before the trademark is actually used in commerce. And the benefit of that is this. When you file an intent to use trademark application, which can sometimes be done within a day, you get national constructive use, meaning that as the day that we file that federal trademark application with a bona fide intent to use this product or service in commerce, even though we haven't yet, it's as if it gives you the same legal effect as if you were using it in all 50 states. So it is very important to use the intent to use system, the ITU system, to establish a priority date, a date of ownership over people that may subsequently try to use that trademark. An important limitation of the ITU trademark is you don't want to have to transfer it. So you don't want to file it in your name individually. In almost all cases, we recommend that the client form a corporate entity, an LLC, an S-Corp, and then the ITU trademark, intent to use trademark application is owned by that entity. Why? Because you can't traffic in trademarks. You can't buy a bunch of intent to use federal trademark applications or secure them and then go sell them like domain names that you had acquired. You actually have to have a bona fide intent to use, and you cannot just sell them ad hoc. But if that intent to use trademark application is owned by an entity, you can transfer that intent to use trademark application if you're selling it with substantially all the assets of that corporate entity. So when the ITU trademark is filed, you typically undergoes examination first, although there is a opportunity to file an amendment to alleged use to show that you started using it in commerce before the examiner picks it up in about 3 to 4 months. But typically what happens is it gets approved for publication, and during that time you're in a blackout window and you can't submit evidence that you're using it in commerce, even though you still may decide to go ahead and start using it in commerce and not wait for the federal registration to come through. So once it's gone through the publication phase and it's become allowed, you have 6 months from that notice of allowance to file a statement of use. Sometimes within those 6 months you may still be in the planning stage of your company or for that product or service, and you can continue to request 6-month extensions with the payment of a fee, and that can go out from 3 years. If you haven't started using it in 3 years, then that trademark application, even though they would allow it otherwise, will have to go abandoned. Once you have your federal trademark registration, you have to maintain it. and there are renewals and government fees that have to be paid to keep it alive. So if you register it on year one, you're going to have to file a Section 8 declaration of continued use after 5 years. Now during that time you can also file a Section 15, which is your declaration of incontestability. So typically at 5 years you file a Section 8 and 15, and you also have to submit evidence that you're still using it in commerce. So if it's a tangible product, it's usually a digital photo of the brand associated with that product as a tag or imprinted directly on. Or if it's a service, it's generally a screen capture of the website. So once that renewal is done, at year 10 you have to file a Section 9, your renewal of continued use, and again file another specimen or example of use in commerce. And then it goes in blocks of 10 years, 10 years, 10 years, for as long as you continue to use that trademark and as long as you want to maintain that federal trademark registration.